This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about a challenge to a guilty plea on insurance fraud that failed, and why when an insurance fraudster admits guilt, he must serve the time, because post-conviction review resulted in affirmation of his sentence. Lewis R. Brown appealed from the December 20, 2023 order entered in the Delaware County, Pennsylvania Court of Common Pleas, denying his petition filed pursuant to Post-Conviction Relief Act as meritless. In the case entitled Commonwealth of Pennsylvania v. Lewis R. Brown, the Superior Court of Pennsylvania Appellate Division on March 24, 2025, reviewed his appeal after his request for post-sentence motion to reconsider his sentence was denied. On June 21, 2022, the appellant Brown entered an open guilty plea to insurance fraud, theft by deception, criminal use of communication facility, and conspiracy to commit insurance fraud. In pleading guilty, Brown admitted that he called his insurance company regarding a fraudulent claim from Delaware County and received payment for the fraudulent claim at his residence in Delaware County. On August 15, 2022, the court sentenced Brown to a term of 18 to 48 months of incarceration, a concurrent term of 6 years of probation and restitution. Plea counsel filed a post-sentence motion for reconsideration of sentence, which the trial court granted, and resentenced appellant Brown to a term of 15 to 36 months of incarceration, a concurrent term of 6 years of probation and restitution. On October 11, 2022, Brown obtained new counsel, who filed a motion for reconsideration of sentence which the trial court denied. Then appellant, acting as his own lawyer, filed the PCRA petition, and the PCRA court appointed counsel who on March 14, 2023 filed an amended petition. In the amended petition, Brown came up with an amazing assertion that Philadelphia County was the proper jurisdiction for this matter because the conduct underlying the damages against him occurred via telephone communication in the city of Philadelphia, and no criminal behavior occurred in Delaware County, so his plea of guilty should be rescinded. On September 19, 2023, the PCRA court held a hearing on the petition, permitting Brown to speak. Brown stated that he believed that Delaware County lacked jurisdiction because all of his criminal conduct occurred in Philadelphia County. Appellant's counsel raised the following issues. 1. Did the PCRA court abuse its discretion by denying appellant's PCRA petition after a hearing where he presented evidence that jurisdiction and/or venue was improper in Delaware County, Pennsylvania, where all the criminal conduct occurred in Philadelphia County? And 2, was the plea counsel ineffective for failing to challenge venue and/or jurisdiction where all criminal conduct occurred in Pennsylvania County? To support the motion, counsel is required to submit a no-merit brief. 1. Detailing the nature and extent of her review. 2. Listing each issue the petitioner wishes to have raised on review. And 3. Explaining why the petitioner's issues are meritless. The court then conducts its own independent view of the record to determine if the petition is meritless. An appellate court must give great deference to the findings of the PCRA court if the record contains any support for those findings. The PCRA court's credibility determinations are binding on the appellate court. A petitioner must establish that the issues raised in the PCRA petition have not been previously litigated or waived, and that the failure to litigate the issue prior to or during trial during unitary review or on direct appeal could not have been the result of any rational, strategic, or tactical decision by counsel. Notwithstanding Appellant's claim at the PCRA hearing that his criminal conduct took place only in Philadelphia County, the record reflected that Appellant received payment on the fraudulent insurance claim underlying this matter at his residence in Delaware County. Thus, venue was proper in Delaware County. And in fact, given that Delaware County had jurisdiction over the matter and the venue proper there, the trial court would likely have denied any motion to transfer venue, and thus the outcome of this case would have likely been the same. The PCRA court's decision is supported by the evidence of record and free from legal error, and accordingly, Appellant's claims merit no relief. The order of the PCRA court was affirmed. In my opinion, the Commonwealth of Pennsylvania has created a post-conviction review court to allow convicted criminals to review the sentences handed down by the trial court that convicted him. In this case, after pleading guilty to the crime of insurance fraud, he was upset by the sentence he received and appealed it. He was able to get it modified once and tried to say he was tried in the wrong jurisdiction to remove the sentence. His arguments were specious, and the appellate court did not fall for his scheme, and he will spend his full term in prison. This video is adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 5,000 blog postings. If you can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.